Should tech companies have legal immunity from the content that users post online? The question goes back decades, but now the Supreme Court is set to weigh in on a case that could have major implications for social media. Justices took up an appeal yesterday by the family of a 23-year-old American woman who died in an ISIS terror attack in Paris 7 years ago. Her family sued YouTube's parent company, Google. They claimed YouTube's algorithms promoted videos about violence from the terrorist group. The case centers around a controversial law called the Communications Decency Act. Congress passed it in 1996. One of its provisions is a section known as Section 230. It says tech companies are not liable for what users post on their sites. In other words, the companies can't be sued for what you do. But there are growing calls from both Republicans and Democrats to change that sweeping protection. CNBC senior Washington correspondent Eamon Javers is tracking it all. Hi, Eamon.
Shep, this is a Supreme Court with this new 6-3 conservative supermajority. It's demonstrated it's just not afraid of making sweeping changes to American life. So the social media giants are going to be watching this case very carefully. This will be the first time the court has looked at the issue, although Justice Clarence Thomas has been critical of this specific provision in the past. Now, the argument this woman's family is making here is that the algorithms that recommend videos similar to ones a user has watched in the past are actually responsible for pushing more and more extremist content at vulnerable people. So now the court could make dramatic changes to Section 230, and that would have sweeping consequences for just all kinds of sites that use automated systems to sort user-submitted content. Think Facebook, TikTok, Twitter, Instagram, even Wikipedia maybe. And it could remake the types of things that companies can allow on the internet.
That will also mean that they're going to be very careful about what kind of speech they allow on their platforms. So it's going to be a sanitized internet, devoid of controversial speech, because that controversial speech is the kind of speech that might lead to liability.
So why is that? Well, for decades, the law has not treated social media companies like publishers. If a magazine publishes an article that's defamatory, the person who is defamed can sue the magazine, not just the writer of the article. That doesn't happen on social media, largely because of this protection. And if it's reworked, it's easy to imagine social media companies just drowning in lawsuits from all sorts of people angry about one thing or another that's been posted on the internet. And Shep, if that's not enough, the Supreme Court here is also taking up another social media case, this one involving Twitter, that could set the standards for what tech companies' responsibilities are when terrorists are using their platforms. So that's something else for the Silicon Valley lawyers to pay attention to this session, Shep.
Thanks very much, Eamon Javers. Shepard Smith here. Thanks for watching CNBC on YouTube.